Okay. Can everybody out there hear us? Let me pull the chat box up here too now. Can I get some confirmation from those of you watching out here that the audio is live? Could anybody reply in the chat box? All right, audio is live. We're good to go.
Well, good morning. My name is John Tribuiano, and we're here to talk about the FB 863, the new workers' compensation reform. Like I said, John Tribuiano has been with the firm for the last 8 years.
Jonathan Liff. I'm also in the workers' compensation department at Mastagni Law firm. Been here for about 12 years.
I'm John Holstedt. I've probably been here the longest, 33 years. I've gone through quite a few of these law changes, so hopefully we can shed some light to everybody on what it may mean to you as public safety. Thank you.
And I'm Eric Ledger. I'm fairly new to the firm. I've been here a little over 1 year, and I've gone through the whole bill, every line of it, and we're ready to go from that. It looks like from the chat, somebody's having an issue with the audio. Said, I'm not hearing anything on the feed. FYI, I tested my audio with a little test tool and it's working. Well, other people are able to hear us fine, so the one person who is having issue with the audio, it might be a computer problem. I'm seeing chat from everybody else saying that their audio is fine. But for those of you who might be having issues, we are recording today's teleconference, so you will be able to view it later. If you want to download it off the internet, we'll have that available for posting. So if you're unable to view, or if you know anybody who registered for today and is unable to attend the conference live, they will be able to view it off the internet later on. So that being said, let's get into the presentation. We're here today to talk about Senate Bill 863. This is a workers' compensation reform that was run through the legislature in the last week of its business in August. Jerry Brown signed it into law, I believe, on the 19th of September, so it is going to be the law of the land. The issues we're going to cover this morning, we're going to talk about some of the main points of the law, and what we focus this presentation on is how it's going to affect yourself and your clients as the injured worker. There are a lot of changes in the law. So many changes you really cannot cover it in 1 hour presentation. But what we're focusing on is what and how the law is going to affect the injured worker. And just 1 second, please. I'm getting replies from several people that they cannot hear us. Just a second as we try to fix this. It's more than one person. It's at least 7 or 8 people are saying they cannot hear the audio. Just 1 second for those who can hear the audio. We're going to try to correct this problem. Where's the level of the microphone? Have we checked that and everything's set right? All right, just 1 second, folks. Yeah.
Technical difficulties, please stand by.
Okay. So I've given a little note here to those who cannot hear the audio. It could be a computer problem. It could be their speakers aren't turned up. Who knows? But again, if you're not getting the audio, we apologize for that technical difficulty. But everything we say here is going to be available for download later off the internet, so you will be able to watch it at another time. So just to talk about the main issues we're going to cover today, we're going to go over some of the big changes in the law as it affects the injured worker. We're going to talk about the independent medical review, some changes in utilization review, We'll talk about how injuries are rated under the new bill and how it's going to change the amount of permanent disability the person might be able to see into their pocket. Then we're going to talk about some job displacement vouchers and finish up with some issues that are going to specifically cover the public worker and peace officer community. So, the main change in the law is that there's now going to be independent medical review of any future medical disputes in workers' compensation. For those of you who haven't had a work comp case and you're not sure exactly how it goes, under the present system, if you have a future medical dispute, in other words, your treating doctor under workers' compensation is suggesting you have a surgery and your insurance company is denying that surgery be approved, then you would object to that denial, and then we would then send it on to a qualified medical evaluator, who we call the QME, or an agreed medical evaluator, who we call the AME, and we would get that doctor to comment on whether or not the surgery is appropriate. And that doctor, he's somebody who's seen you, he's somebody who's evaluated you as a person. You've been in his office, you've gone through an examination, and that's a doctor who has reviewed your entire medical history and written a report basically telling us exactly what's wrong with you from a work perspective, a work injury perspective. And so under the present system, that's the doctor who's going to ultimately decide whether or not your surgery, for example, is going to be approved. Now, the new system is taking the medical decisions away from the QME or AME, and they're placing them into what's called the independent medical review. This is a system that was borrowed heavily from how private insurance handles disputes over medical treatment. So we're borrowing heavily on that system, and we're going to bring it into the workers' compensation realm. And there's some issues, I would say, that applicants' attorneys have some issues with the independent medical review. We'll talk about them. But what you need to know for when you're talking with your workers about work comp reform, this independent medical review, it's not going to affect anything that happens up until 2013. So it's starting in January 2013, for any dates of injury on that date or in the future, that's where it's going to affect you immediately. If you have an injury now, it's not going to affect you until July 1st, 2013. So eventually everybody's going to be brought into this system of independent medical review. It's just a matter of time. Now, the independent medical review is going to be the sole and exclusive remedy regarding medical treatment issues under workers' compensation. So, with the independent medical review, basically whatever that doctor decides is going to be the law of the land as that doctor decides it. There's not going to be any basis for review or anything else. Another issue that we all have as applicants' attorneys with independent medical review is it's entirely based on a medical record that is submitted to the doctor. And that medical record could only be maybe 15, 20, 30 pages regarding the authorization. It's not necessarily a doctor who has reviewed the patient's entire medical history and given us a complete summary of everything that that patient has had leading up to that surgery request. So it's a limited review based on a medical record, based on a doctor that is not evaluated the client in any personal capacity. There's no physical examination of the client. Then, in our belief, our collective belief is that's going to lead possibly to the wrong decisions being made in certain cases. So, one of the big issues surrounding independent medical review is that there's a limited appeals process. Now, there's 5 grounds that you can appeal the decision. So, let's say that the doctor in this hypothetical case recommends surgery for you in your workers' compensation case. And that surgery is denied by the insurance company, and you want to appeal that denial. So you go to the independent medical review, and let's say the independent medical review continues to deny that surgery. Well, you've got 5 grounds that you can appeal that, and that's that basically, they're right here on the slide. The administrative director acted in excess of powers. Determination is procured by fraud. the independent medical reviewer had a material conflict of interest, was biased, or there's a plainly erroneous express or implied finding of fact. Now, the problem with all 5 of these, and any attorney you talk to is going to say the same thing, that it's almost impossible to prove any of these 5 things. And that's particularly true because you don't know the identity of the doctor who is doing the review. So if you don't know the identity of the doctor doing the review, number 3 and number 4, conflict of interest and bias, I'd love to know how anybody's going to be able to prove that. When you look at number 5, you got the plainly erroneous finding of fact. That's only factual errors that are within the ordinary common knowledge of a person. So if the medical reviewer comes back and he's supposed to be reviewing a back surgery, and he says in his report, the knee surgery is not authorized, that's plainly erroneous. All right? What you don't get to appeal on is his expert opinion, which is what we really want to appeal on. If the independent medical review comes back and says you don't need back surgery, that's the reviewer's expert opinion, and that is not reviewable at all in any court system in the country according to the text of the statute. Now, we'll get into that in a minute as far as constitutional issues, but the bottom line at the bottom of this is even if you do win the appeal, the only thing you get is a second independent medical review. You don't actually get a judicial order saying, no, the independent medical review is wrong, you deserve the back surgery. The only thing you're going to get is a second independent medical review. Go ahead.
The question I think, is on my mind is which doctors are going to be doing these independent medical reviews. What we know is that the administrative director has been empowered and ordered to basically decide or do research and figure out which doctors are going to be included in these independent medical review panels. We know that starting January 2014, doctors who are qualified medical evaluators will not be eligible to be part of the independent medical review panels, but it appears at least during 2013, QMEs will be able to act in that capacity, but besides that, I don't know if these doctors are really familiar with it all, but it won't matter because we want to know what their names are. And I don't know, Eric, are you familiar at all with the doctors that are using this one during the private insurance system and how that applies?
No, we haven't looked into that, but basically the wording of the statute is the administrative director is going to contract out all of these services through independent medical review organizations, and through those organizations they have to ensure that all the doctors that are doing the independent medical review are in statutory compliance with all the various requirements of the code, that they not have certain conflicts of interest, that certain other things apply. And the understanding is that they are going to contract, more than likely they're going to contract with the same organizations that do it for private health care, but that remains to be seen. Nobody really knows exactly how that's going to happen.
And there is a preference, I believe, that the doctors are from California versus out-of-state doctors?
But the statute says there's a preference for California doctors, but the only requirement is that the doctor be a licensed as an MD or a DO, which is, so just because there's a preference that the doctor be here in California does not mean that there's a requirement. The doctor can be based anywhere in the world as long as he's a medical doctor or he has his DO doctor of osteopathy, right? Yeah. And by the way, if anybody out there has any questions, I'm monitoring the chat box if you see me looking at the computer here. So far all the questions seem to be technical, and Tommy is taking care of those. But if you have any questions as we go along in the process, if you type them in the chat box here, I'll monitor them, and then we'll throw them to the panel for some comments. Okay. Let's go on to the next slide. So here's the issue. Here's the number one issue with independent medical review is that the WCAB and no court higher, no court, not even the Supreme Court of the state of California, has jurisdiction to overrule the IMR's determination. And we can throw this to the panel to talk about the constitutionality of it, but My understanding is, talking with most of the people, including attorneys who have reviewed this, is that it would likely be unconstitutional. Anybody want to throw in their thoughts on that?
Well, number one, you have to understand that the California workers' compensation system basically was created under the California Constitution. So with this bill, they have set up a procedure in which there is no judicial oversight to IMR physician's determination. That in and of itself is very concerning. The judges at the Workers' Compensation Appeals Board are very concerned over that issue. Attorneys are very concerned over that issue. I don't know any other procedures that there is no judicial oversight of a decision made by a non-judicial officer. It's very concerning, and I think the legislators knew that this provision was going to be held unconstitutional, and they specifically added a severability clause into the bill, which basically says, look, if this portion of the bill is found unconstitutional, it doesn't affect the constitutionality of the rest of the bill. So, from our perspective, when you're dealing with the current system versus what's going to happen under the Senate bill, is this. We have AMEs and QMEs. Like Eric talked about, your treating physician says, Officer John Doe needs a shoulder surgery. It goes to the utilization review system through the insurance company, and that utilization review doctor, once again, who's never examined the injured worker, just reviews records and makes a decision. No, it's not certified, and we're going to deny the treating physician's request for the surgery. Then, once again, it goes to an AME or a QME, and that doctor examines the individual and then makes a determination, which is basically a tiebreaker. He's either going to say, yes, you need the surgery, or no, you don't. As lawyers, what we have is the ability to ask that doctor for supplemental reports. We have the ability to depose that doctor under the penalty of perjury, or cross-examine that doctor in regards to, do you take A, B, and C into consideration when making this determination. Moreover, there's judicial oversight to those opinions to determine whether the individual actually needs procedure or the requested modality, such as physical therapy or chiropractic treatment or epidural injections or whatever it may be. We even have like over medication, and whether the person gets a vitamin pill or gets something that helps them sleep. So we're now in a situation where the legislators have basically handcuffed the courts, not just the Workers' Compensation Appeals Board, but the appellate courts and the Supreme Court, in regards to, once the decision is made, it is final, and you cannot even address the issue. Moreover, even when we go to the AMEs and QMEs to address industrial causation, apportionment, your permanent disability rating, or your whole person impairment, whether you're still temporarily disabled or permanently stationary, those doctors can't even address those issues, or they're not supposed to address those issues. And if they do address those issues, it has no force and effect at all. So that's what's the most concerning for us on the legal aspect of representing these workers, is the lack of judicial oversight and the chaos that's going to ensue. Because I can tell you what, a judge is going to have a hard time saying there's no judicial oversight in regards to some doctor who no one even knows the identity of that doctor's decision on whether someone gets medical treatment or not.
All right, we've got a couple of good questions here on the chat box that I'm going to throw out to the panel. So the first question is, if you have an injury now and you're not permanent and stationary, if the injury is not permanent and stationary before 7/13, it's July 2013, then will it be up to the IMR if you get surgery, or will it be up to the QME-AME? You want to take that, John?
Right now, the way it's set up is starting July 1st, 2013, even the surgery questions will be answered by the IME. So you don't have the second opinion surgery procedure that's in effect right now, which gives you a chance to fight UR. You know who the doctor is. The individual who's injured goes to the doctor, sees the doctor, records can be provided to the doctor, and then that doctor gives his opinion on whether UR was right or wrong. That's going to be gone and go to an IMR, and we won't know who that doctor is. That doctor won't be able to be attacked on anything because we won't know who he is, whether he has a bias, whether he's got an affiliation with another company, or whether he's really confident to make that decision. So you will be bound by that, and it will be the same process that's going to go into effect for injuries that occur starting 1/1/13.
Even in situations, I think, where you have an A&E who is addressing medical issues up until that point, every dispute that arises on or after July 1st, 2013 is no longer under the province of the A&E, and it's going to go to IMR after that.
So we've got another question here, a good one. Is anybody going to challenge this soon, or do we have to wait for somebody to be harmed by the IMR process?
Well, the issue with that is, since no one has been injured or harmed, the issue is not right. And so we don't have standing to challenge that issue at this point in time until there's an agreed party. And so once the issue comes up, then it's going to start getting challenged, what we call taking it up to flagpole. So the first thing, the workers' compensation judge, and they're always talking about this at the courts here today, is in regards to, look, as the trial court judge, I'm here to follow the law, not change the law. That's called, being judicial activism. So I'm going to have to follow the law, and then someone's going to have to take it up to the Workers' Compensation Appeals Board and see what they say. And then at that point in time, if they make an adverse decision, then we're going to have to take it up to the Court of Appeals and so on. But we are going to have to wait until someone is harmed under this new process before we take it up to Blackwell.
And it's going to take some time to get up to the Supreme Court. I mean, a couple of years potentially.
And you have to realize that after the first law change during my career, probably the biggest fix during Mr. Holstedt, is after the 2004-2005 law changes. Those cases are still being litigated in the appellate courts today. Mr. Holstedt recently had a published decision in the 3rd District Court of Appeals addressing some of those issues. These decisions are coming out on a monthly basis, even now, from the law that went into effect 7-8 years ago. So, those issues under the prior law are still floating around the appellate courts and the Supreme Court at this time.
All right. Tommy, you want to come in there? Tommy's our IT guy. We've got some issues with microphone placement, and that was his crutch right there into the shot. Not work injury. All right. So going on next in the slide, we've got the IMR. They have to be independent under the law. That means they cannot have a material financial interest in a workers' compensation carrier or anything else related to the injury. Now, the question I have here on this is that they define a material interest as not having a source of income or revenue greater than 5% from a single source. So the question I have on that, though, is can you have IMR doctors where you've got, 4% of my incomes from Travelers, 4% from Skip, 4% from Zurich? Can you have it from all of these different insurance companies and then still be independent when you're doing your IMR process?
Well, I think an even better question to add to that is that in the bill, a lot of times it refers to the independent review organization rather than any independent or individual doctor within that. And so it really refers to almost like a network of doctors rather than a particular doctor. So I'm not clear exactly how that's going to apply.
Let's see, we've got another question here. If you were awarded all future medical care, will the IMR be able to change that? And yeah.
So addressing that issue, when you get an award, it basically says there is a need for future medical care to help cure or relieve the effects of the industrial injury. Okay? At this stage, what we do is rely upon the A&E QME in their reports to basically outline what that future medical care is going to be. So a lot of times the doctors say, look, Officer Williams needs a knee replacement at some point in time in the future, and provisions should be made available for that. So that doctor is being proactive by saying, look, I'm going to cut off at the path any future disputes on whether Officer Williams gets that knee replacement or not. Because I am telling you right now, at this point in time, he does not need it. At some point in time in the future, he is going to need it, and those provisions should be made available. Now, under the IMR process, after Mr. Holstedt, after July 1st, 2013, once your treating physician says it's time for Mr. Williams to get that knee replacement, it's going through IMR, and that previous opinion by the A&E or QME is going to be held invalid.
All right, let's keep the presentation going. There was a lot of talk with attorneys about trying to get around the IMR. You know, my contracts professor at first year law school said there's very little you can do in the law with when you have mutual assent of the parties. In this case, you can't do it. There's a specific code section that says you cannot agree to use a QME or AME to determine medical issues. So even if both parties want to say the AME can decide this issue, we'll send it to him. Technically, under the law, you're not supposed to do it that way. Now, we'll go on now from the IMR. If there are any more questions about the IMR, we can wrap those up at the end of the presentation. Let's move on now to some changes in utilization review. Now, for those who don't know that term, utilization review, when you have a work comp injury and your doctor, your primary treating doctor, is requesting authorization for something, let's stick with the surgery example. When your primary treating doctor is requesting back surgery, that gets sent to the workers' compensation insurance company, and in the statute, they have 5 days to make a decision on that or to request more information regarding the surgery. And that process where they're making the decision is called utilization review. Basically approving or denying your surgery with in-house doctors of the insurance company. Now, presently, if your treating doctor sends a request to utilization review and it's denied, then as your attorney, I'm going to tell you, we'll go back to your doctor and get him to send the request again and justify it better, is what I'm going to tell you to do. They've changed that in the new law, and the new law says that when utilization review is denied on something, then that denial is effective for 1 full year, unless there is a substantial change in the facts that affect the determination. So that's going to affect a lot of people, particularly if you're looking to get a surgery done and you're denied the surgery and IMR denies the surgery, then the issue is you don't get to request that surgery again for another year. You've got to wait 12 months. And the only other way that we can creatively come up with to get around that is you'd have to change your treating doctor. So the new law requires you to either wait 12 months to submit the request again or get a new treating doctor, unless there's been a material change in facts. So that's that, and it doesn't look like we have any questions on the utilization reviews, so we'll keep going.
But just real quick,
go ahead.
We really suggest that you get and select a primary treating physician who is conversant and familiar with workman's compensation law, because you want that first request to have the appropriate documentation and justification so that you're not just having to wait another year to get it done right. So it does help if you pre-designate your primary treating physician, make sure it's someone who knows workers' compensation, or exercise your right after your first 30 days to get a physician that will help you get through this process of getting authorization, so not just sending in a little prescription slip with no justification and having it denied by UR.
And that is a really important point, and bears repeating, especially since that the initial doctor you get sent to after an injury, having pre-designated your own doctor, is almost always going to be an occupational medicine doctor. And those doctors are, generally speaking, very much in favor of keeping the employers happy and keeping costs down. So, like Mr. Holstedt mentioned, 30 days after the injury, or 30 days after it's reported, you can switch treating physicians, and it's recommended that you do that, especially if you're in the employment of occupational medicine doctors.
We've got a good question here, actually, from somebody. If the question is, if utilization review gets denied and I have to end up waiting a year for a surgery, how is that going to affect my workers' compensation case in the meantime? And it would depend on your specific, it would depend specifically on the facts of your case, but I could certainly see a scenario where that might extend your temporary disability or your 4850 time or your industrial disability leave while that surgery is still pending. And that is certainly an argument that we can make for those injured workers.
The problem is there's a finite amount of events you can speed under 40, 50 or 10 disability, and that can certainly cause problems if there are these types of delays in getting treatment authorized.
And, you know, at this point in time, we've been kind of using the example of surgery, but you have to realize this applies to all treatment modalities. Your treating physician requests physical therapy. Your physical therapy is denied. That same doctor cannot put in that same request for another year. So, and as you know, Mr. Liff talked about, is your 4850 times 1 year. Your temporary disability is 104 weeks. So if you're waiting 1 year and you're off on 4850 or temporary disability to get that authorization put back in, let's say the second time it does get approved, okay? Now you have, once again, a limited amount of time beyond temporary disability before it shuts down after the 104-week cap, which is 2 years. So, you know, there are big issues there. We're talking about surgery, but we're also talking about medication requests. We're talking about physical therapy, chiropractic treatment, epidural injection, and any other type of treatment modality that your treating physician prescribes. If it is denied, and it goes to IMR, and that denial is upheld, you don't get a request again for money.
We've got another good question here on the chat board. Question is, with the introduction of the IMR process, will Mastagni Law firms still be heavily involved in the workers' compensation cases as it relates to future medical issues? And as a subset of the question is IMR going to affect the effectiveness of the workers' compensation attorney?
Well, I think that we've always in the past assisted all of our clients who we've represented in trying to obtain the medical treatment that has been awarded by a workers' compensation judge, whether it's an old case or as we proceed on the present cases. So we definitely will take an active role. We've been educating treating physicians in the area in terms of what we expect out of them to best assist our clients in getting the treatment they need. And so, yes, we simply will continue to represent our clients as best we can, as hard as we can, trying to get medical treatment when it's needed. And we'll work within that system and try to educate the physicians and treaters who treat our people, you know, during the course of their injury and thereafter.
The issue with the IMR is, in regards to our role with that, is providing all the documentation necessary for that IMR doctor to make an appropriate decision, knowing that you're not going to be evaluated or examined by that doctor. So, on one hand, what did the insurance company send to that IMR doctor for review? What are you going to do if you're representing yourself, or what are we going to send that doctor to make sure that he has the entire record? Okay, you know, we're talking about a surgery for a knee. What an MRI of that knee, which shows the the lateral tear, is not included in that package. That IMR doctor is going to say, hey, I don't even have an MRI showing that there's any pathology there. All I have is symptoms, and so I'm not going to approve the surgical request. Well, it's up to the attorney or you're representing yourself to make sure that doctor has all that information. And that's how we're going to be involved in the process. The second step how we're going to be involved in the process is, I think we're going to be on the front line of taking this thing up the flagpole and making this, getting a determination whether this is constitutional or not. Because we don't think it is. I just don't think any procedure, any type of law, in any field of practice where there's no judicial oversight can be held constitutional. That is no different than someone making an IA claim against you and then saying, okay, well, the complaint's been made. Here is the IA officer's determination, and there's no judicial oversight, there's no review process. It's the same type of concept. So, our role in this thing is making sure that IMR doctor has all the documents necessary to make a determination. Another interesting issue is that IMR doctor actually going to be independently reviewing the film, him or herself, versus relying upon a radiologist interpretation or a radiology report. I don't know how many situations I've had where doctors will actually review the film, disagree with the radiologist's interpretation of that film, based upon his or her own independent evaluation of that. And so, there's other issues too. Is, can we get the IMR doctor the actual film of your knee, of your shoulder, of your back, versus him or her relying upon a radiology report and relying upon the opinions of a radiologist. So that's how we're going to be active in that role.
I think the legislature anticipated that the IMR process has to work better than the UR process. They've set out rules that the insurance company is supposed to provide them with the IMR with the relevant records, and we have an opportunity to provide the IMR with relevant records. The injured worker has the opportunity. They have more time at the IMR to make their decisions. They don't have to turn it around in 5 days, and they're not being paid by the insurance company and set up by the insurance company to review like UR is, and they know that their job is to turn down as much treatment as they can to cut the employer's costs. So we're hoping that the IMR is going to be more workable, more defeatable than UR, and we're just going to have to marshal all of our efforts in that, and that's what we'll do, just like John said.
All right, there's a lot of questions here on the side. We can't get to all of the questions that are coming in, but by all means, if you have questions, you can email them to me or anybody on the panel, and we can try to get back to them, or you can call the main line to the office, which will be at the end of the slideshow, and you can ask to do a consultation with one of our attorneys. So let's keep moving on. We'll talk about rating of the injury. Now, this is some good news for most people and some bad news for some others, but the rates for permanent disability are going to go up beginning in 2013 for some injuries and beginning in 2014 for all injuries. So if you look at this slide, for present injuries, the rate of permanent disability, and this is how much is paid out on a weekly basis, is the minimum is $130, and most people will get the maximum rate, which is $230. And in order to get the maximum rate, let me just step back and explain. Permanent disability is rated at 2/3 of what your average salary is at the time you're injured. And so whatever your salary is, you times it by 2/3, and that's your permanent disability rate. Most people, unless you're making very little money, most people will hit the maximum rates on permanent disability. So presently, you max out at $230 a week. Starting in 2013, the maximum rate will go up for injuries depending on the level of permanent disability. And in 2014, the level will go up to $290 per week for all disability levels. Now let me show you how that would affect just your normal injury. We'll come back to this slide in just a second. So on this slide, you take your normal injury of, let's say you've got a 50-year-old police officer who has a 10% rating on the back, the low back, a very common injury. So in 2012, if you look, this would rate out to 20% permanent disability, and that would mean $17,365 in actual money. And this can adjust up or down 15% depending on whether a return to work offer is made. When you look at 2013, that rating will actually increase to 23%. And that's because the future earnings capacity is taken out, and instead they give a multiplier that will actually increase the rates of permanent disability. It's a little technical to get into details exactly each and every single multiplier on how you rate out these strings into workers' compensation. But in brief, basically one of the multipliers, they've increased to the maximum rate of that multiplier. So that's a good benefit for the injured worker. And so when you look at rating the injury from 2012 to 2013, you're actually getting 3% more permanent disability. Now in 2014, when the max rate goes up to $290 per week instead of $230, this actually means a total award of $26,245 to the injured worker's pocket on this hypothetical injury. So basically what this slide is saying is for most of your injuries, which are your minor level injuries, less than 50% disability, the injured worker is going to see the permanent disability rates go up, and they're going to see their actual percentage of disability is likely going to increase under the new law. Now
I think in public safety circles, there's always concern that you know, the higher my rating goes up, the greater chance there is I may get inadvertently retired. And just so we're clear, the number you get on the rating does not determine whether or not you're going to get involuntarily retired. It's always going to be a question of whether you can perform your essential job duties. So, in case there's any concerns about the number rating going up and any correlation between their employment status.
Now let's go back one slide. Presently, there's a 15% increase or decrease if there's an offer of work given, and you get the increase or decrease regardless of whether you're back to work. It's the only question we're focusing on as attorneys was, did they give you a form, and did they fill out the form properly and do everything that they had to do? So in this form, it can be the cause of a lot of litigation, actually. There's a lot of cases where there's debates about whether or not the form should apply, whether it was given. If it was given, was it properly filled out? All of those are going to go away for injuries occurring starting in 2013. They've decided that this particular 15% increase, decrease, it just causes there's too much of a cost on the workers' compensation system with all that litigation. So that's going away. Here's another issue. For certain people, this is going to affect their permanent disability rating. There are certain things in workers' compensation, they're called sequela. And basically what a sequela is, let's say you have an injury to your back. And the injury to your back is causing you pain, unbelievable pain, constantly for many months. And as a result of that pain, you're suffering now from depression, which is a very common occurrence. Now that depression, it's called a psychiatric sequela. It was caused by your back, the pain in your back. And presently, under the present system, for 3 of these types of sequela, a psychiatric sequela, a sexual dysfunction sequela, or a sleep dysfunction sequela, those 3 sequelas, those can be rated out for permanent disability under the present system. And you can actually receive significant amounts of rating on some of these. There's a case I was working on this morning where my client was getting somewhere in the 20s on the orthopedic claim as far as permanent disability, but then the psychological aspect bumps it up to 50%. And so on certain individual clients, this can affect their permanent disability rating a lot, because under the new law, none of these sequelas will have permanent disability ratings. Now, you will still get medical treatment for any of these issues that result, and you can still get temporary disability if these issues require you to take time off of work. But because you're not getting the permanent disability rating on these 3 sequelas, for people who would plead this, for people who suffer from these 3 disorders, then they're probably going to see their permanent disability rates decline. There's an exception to the psychiatric sequela if you were a victim of a violent act or you were a victim of a violent exposure. And then there's a third exception if it's a catastrophic injury, and Lord knows how much litigation that is going to cause.
What's interesting about the quote-unquote psychiatric sequela, and what we commonly refer to as a compensable consequence, and it talks about a violent act or violent exposure. Now, this doesn't cut off all psychiatric and psychological claims. It only cuts off the sequelae, compensable consequence. So, I'm not really sure what the legislator was doing here by saying that this is an exception, but if you're involved in a shootout and you start experiencing psychological or psychiatric symptoms, now that is a direct claim, which is still compensable under the workers' compensation system with permanent disability. So what we're talking about is, like Eric was talking about, you have a low back, you end up having a low back surgery, you can't sleep, you can't get comfortable, you have difficulty falling asleep, you can't stay asleep very long, you have a difficult time getting erections or ejaculations, and then you become depressed. You know, I had the same thing. I had a case that was 12% orthopedic, and it ended up rating out at 47 after you add the psychiatric, the sleep, and the sexual dysfunction, and you're talking about a $50,000 swing there between those. But like I said, the direct psychiatric claim, and you see that a lot with law enforcement in regards to shootouts. You see a lot with patrol or traffic officers who have to respond and pick their kids up off the ground. You can see that with some detectives who are in type of FDU type of units in regards to child pornography and things like that. They start getting direct psychiatric or psychological symptoms as a result of work. On those cases, we're still going to be able to bring as a direct consequence. But the interesting thing, the area of litigation in this is the quote-unquote catastrophic injury, because nowhere is there defined in the labor code and the regulations in regards to what a catastrophic injury is. Some of the examples were given, but other areas in California law, it talks about a material effect on your life. And so, issues of if you can't work anymore because of your low back injury, is that now turn that into a catastrophic injury? Like I said, that's going to be an area of litigation from here up through the appellate courts throughout the state of California until ultimately the Supreme Court decides on that issue. We've set the boundary on that issue. But once again, sometimes you have to take these cases up numerous times to get the boundary, because the appellate court only going to rule on the facts of your case and whether this is a catastrophic injury or not. Now, when Deputy Jones comes in, now it's his analogous to that, or is it different? And so, like I said, this is one of them that's going to go up to the flagpole many times. It's going to be very fact-specific.
And I think for many years you're going to be having cases to try to decide what is a catastrophic injury, just like under the current law, there are still cases deciding what constitutes a sudden and extraordinary event, and that's in the law for many years.
There's a lot of questions on here, and I'll summarize them all, and they want to know whether or not the new rating schedule or the new rules regarding sequela, will those be applicable to all the old injuries, or will it only be 2013 and later? And the answer to that question is that's only to injuries with a date of injury January 1st, 2013 or later. Will the rates change, or will the sequela rules here change?
And that's going to be interesting because you have one officer who gets injured on December 31st, 2012, and another officer that's injured on January 1st, 2013. Officer A, who got injured in 2012, is going to be able to plead a sleep sequelae because of his low back pain, including him sleeping. The sexual dysfunction sequelae and a psychiatric sequelae, as opposed to the other officer who may have got injured 2 minutes later, depending on how much time of the day it is, who got injured at 12:01. The other officer got injured at 11:58. Officer B is not going to be able to plead those unless we can say that the psychiatric is somehow a catastrophic event.
And I think we saw a lot of these types of situations back when the SB 899 reform happened in April 2004, where people were claiming injuries and filing cumulative claims right before the end of the year 2004, before a lot of the 2005 effects went into law. So we'll probably be seeing that here as well.
I think there's also a provision if you can show that the loss is disproportionate to the recovery. In other words, you simply cannot work anymore. There's a special fund being set up. They haven't put out any rules and regulations or defined it at all as to how you get into that fund. But believe me, in most cases, we'll be trying to get into that fund. Because
how much is it annually?
$120 million annually will be presented in that fund. So let's keep going on, chugging along here. We're talking about permanent disability advances. So under the present law, once the employer knows that you have permanent disability as a result of your injury, then they have to do a good faith estimate of that permanent disability, and they have to begin advancing you checks for your permanent disability. The new law is not going to require any advanced permanent disability if you're given an offer of a permanent modified position or if you return to your job, making 100% of your earnings. And I know Jonathan had an interesting comment on this, about whether or not it would apply to any job or your old job.
Yeah, and I think the language that's in the bill having to do both with the time and payment of permanent disability advances as well as whether the supplemental job disclosure benefit vouchers applies. And there is some ambiguity because there's sections right next to each other that say if you return to 85% of your salary or if you return to the job making 100%. So it's hard to explain why they put it in there if it wasn't for the purpose of saying that if you go to a new employer, you're making what you're making to the original employer. they have to make advances or issue the supplemental job displacement benefits.
And unfortunately, that's what happens when you only allow 1 week for comments before you pass the bill. But it is what it is, and we'll have to litigate that issue out. So for those who would normally have received an advance payment of PD, if you get a return to work offer and you're back at your job, then your PD will be settled out and it will be paid. Lump sum that was due and payable during that time will just accrue, and it will be paid to you in lump sum at the time you settle your case.
Or at the time of an award by the judge.
True.
Which is, you know, concerning to an applicant is because how long can a defense attorney or an insurance company drag this out while they keep your money in their bank account collecting interest? Yes, this one individual claim, yeah, it's worth $20,000. But when you take that into the aggregate, you're talking about millions or potentially tens of millions of dollars. And now they're just paying off the permanent disability awards with the interest that they receive off that money, so they don't have to make those advances anymore. So the concerning thing from my perspective is, you know, is that defense attorney now going to drag this out? You've got a permanent stationary report, you're rated at 15%. How long can they drag this out before they pay it? And so, as I said, that's when we come in. Obviously, we have a procedure called filing a declaration of readiness proceeding, getting down to the court, forcing the issue, getting these things signed so you guys can get paid versus having them attempt to drag this out for months or potentially even years so they don't have to pay you any money.
You know, it would honestly be even more appealing to the self-insured employers, which most of our law enforcement agencies are obviously self-insured employers in the municipalities, so they have even more motivation to hold on to their money as long as they can.
All right, let's talk about agreed medical evaluators. And again, I apologize, there are a lot of questions on the chat. Some of the good ones we've already answered. If we don't get to your question, then just email it to us at the end and we'll try to get to answering you. Let's talk about agreed medical evaluators. There's the process right now, when you're an injured worker, if you want to get an evaluation done, you can either go to your private treating doctor and you can get that evaluation done through your private treating doctor. And then if you object to that evaluation, you would either get a qualified medical evaluator or an agreed medical evaluator. Now, we shorten those terms to QME and AME. The difference between the Q and the A is very simple. Agreed means both we, as your applicant's attorney, and the defense attorney, we've got a list of however many doctors that we've used in the past that give us good reports, that treat our clients right, and that give us logical reports, which is sometimes just as important. And we use those doctors in the past, and we're willing to send you to them to get your evaluation done. Now, there's some issues with agreed medical evaluators that are coming up that might affect you as the injured worker. And in my opinion, it will. My opinion is it's going to make agreeing to an AME a little bit more difficult, depending on who your defense attorney is. But the new regulations are that once we agree to an AME, we can't withdraw from it unless we put it in writing and both sides agree. Whereas right now, you can withdraw from that AME for any reason. You don't need a reason to withdraw from it. You just say, you know what, I'm not going to withdraw from the AME. We'll go get a qualified medical evaluator from the state of California. Now, then the other issue, which is really more an issue of semantics, but parties, you can submit your cover letters directly to the AME. And the reason I threw this in here, and the reason I think it might affect injured workers, because there's defense attorneys out there that, frankly, I don't trust. And I would never agree to an agreed medical evaluator with certain defense attorneys, knowing that they can send whatever letter they want to the AME, or knowing that if your AME appointment is scheduled for 18 months out, I can't withdraw from that. And so, in my opinion, it might affect the course of your case, in that it's going to force, on certain defense attorneys, it's going to force me to have to go to a qualified medical evaluator. And it doesn't look like we have any comments or questions on that. So, NPN regulations. What is the medical provider network is what MPN stands for. And basically what a medical provider network is if your employer has one, it's a list of doctors that are pre-approved under workers' compensation that can treat you for your work injury. And it's your employer creating a list of doctors like any private insurance company or HMO has. These are the doctors that you can go to. Now there's a lot of new regulations for NPNs that are going to affect you as the injured worker. And particularly when you're treating outside of the network. So that means your employer has an NPN, but for one reason or another, you've gone to a doctor outside of that network. And the most important regulation that I would brief you on, and that we can talk about if there's questions, is that if you were not entitled to treat outside of the medical provider network, so let's say you go to Dr. X for your injury because you trust him, you like him, and you're willing to pay out of pocket. Well, if you do that, and the doctor malpractices you, the employer is no longer required to pay for any of the consequences of the treatment you've obtained. And to me, that is one of the most significant changes, is that they're not going to be required to treat or to pay permanent disability on any malpractice or anything. And so it's really going to affect the injured worker in how they obtain their treatment. There are some regulations out there. You're allowed to treat outside of the NPN for emergencies, or if the employer refused to authorize the doctor within the NPN, or a host of other reasons. But to me, it's that one clause that says they're not liable for any consequences of treatment that I probably object to most. I don't know if you have any comment.
Let me expand on that. I represent a Vacaville police officer who was going to his doctor's appointment riding his motorcycle. A young lady runs a red light and smashes into him. Now, because he was heading to a workers' compensation doctor's appointment, that car accident case is considered industrial. Those are very, very significant injuries. And so the extended period of 40 to 50 times temporary disability was covered under workers' compensation. The permanent disability, the increased permanent disability that he gets based upon that car accident is workers' compensation. And plus the medical treatment is going to be paid through workers' compensation. And so, you know, in that scenario, if he was going to a doctor outside of the NPN, none of those things would be covered. His time off work wouldn't be covered. His medical bills wouldn't be covered. And there would be no increase in permanent disability from that injury. I also represent a salon as deputy sheriff who went in for a 2-level cervical fusion. The doctor started fusing the wrong level. It was 4.556. The doctor believed he was using 4.5 and was actually at 5.6, and then fused the healthy vertebrae below, then realized it was a mistake, and then fused 4.5. So my guy walked out with a 3-level cervical fusion as opposed to a 2. Obviously, he gets medically retired. His temporary disability, his 40 to 50 was off, and his temporary disability gets extended, and his medical treatment. So under this new rule, if that was a non-NPN doctor, he wouldn't be entitled to any of those. This was recently a case came out called Valdez. And the Valdez case said, hey, I understand this is a workers' compensation system, but you can't preclude someone from choosing who they want to treat with, whether it's within your list or not within your list. There's a lot of legal semantics in that case, but basically it comes down to, you know, Jonathan, that if it's injured at work, he can really go to anybody he wants to see. You know, the issue is whether the insurance company or the employer has to pay for it or not, blah, 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 blah. So this regulation came down in you know, as of the Valdez decision, basically trying to curtail it.
And seeing no questions on that, let's continue on. A couple good things. All of your NPN lists, all of the doctors you get to treat with, they have to be posted online, and they have to be accessible online. And the Department of Workers' Compensation is going to have to maintain an online database that tells you exactly where you need to go to figure out who you can and cannot treat with. This is a big improvement over a lot of work comp carriers who will basically threaten you for treating outside the NPN and do everything but tell you how to access the NPN. And so it's become a major issue with work comp attorneys and injured workers in the recent years. And so that'll correct that right there. That's a good change.
Yeah, there are a lot of situations where some insurance companies do have their medical provider networks posted online and they're relatively easy to access. But others would not have them accessible, and you'd be basically at the mercy of the claims adjuster to provide you with a list of doctors from their network, and they would get to handpick the doctors they provide you from that network, and without being able to really access and look through that network, you don't really know which doctors are in it, and which might be the most favorable or beneficial doctors for your clients.
Plus, they have a regulation now that the MPN has to have somebody available pretty much all the time to assist in finding a doctor within that network, because we find a lot of times the MPNs now, the doctors in the MPN don't even know they're in the MPN, don't take workman's compensation, need this referral, need that referral, and it's just a large runaround, and now those MPNs are going to have to assist in finding those doctors and setting up the evaluation. So that's a good thing too.
And before we move on, the MPN, something very important that's not listed on there, and I believe Mr. Holstedt alluded to it earlier in regards to a pre-designation. And a pre-designation is your family tree physician, the person you will go to if you stub your toe at home or if you have the common cold. You can pre-designate that doctor. You can fill out a form. You have that doctor fill out a form. The doctor basically consenting to treat you with the workers' compensation system, agreeing to accept workers' compensation payment, and also agreeing to abide by the workers' compensation regulations and guidelines about reporting. You can go to that doctor if you have pre-designated them prior to your injury. So that really cuts out a lot of these problems about who's on the medical provider network, who's not, who can treat me, who can't, things like that. So we obviously would encourage everybody to pre-designate their family physician. Obviously, your doctor would need consent to that. But I have a pre-designation form, and the people who do have pre-designation, obviously they're just treated a lot better than getting stuff to what they call a quote-unquote company doctor.
Yeah, we have a question on here whether or not the MPNs are going to have more specialist doctors in the list. And there's no regulation as to, there's no change in the regulations into the number of doctors they have to have. But presently, in order to be a valid MPN within a certain geographic area, I think is it 30 minutes or 30 miles? It might be 30 miles. But there's a certain geographic area within your residence they have to have at a minimum of 3 doctors in order to be a valid MPN. So if you need a particular specialist and they don't have 3 of those specialists available within a 30-mile geographic area of your home, then you can go treat with any doctor who is willing to accept California workers' compensation.
Although I believe there are some exceptions for rural areas.
Right. There are exceptions there, and obviously that would depend factually on your situation, and if you needed more information on that, you can contact us.
One of the concerns I do have about the new MPN regulations is they removed the requirement that there was a minimum number or percentage of doctors from the medical provider network who had to be non-occupational medicine doctors. I think it was 25% of the networks had to be non-occupational medicine doctors. They removed that, so we'll have to see how the regulations implement these new rules as far as that goes.
All right, let's talk briefly about the supplemental job displacement vouchers. These are the vouchers that you as an injured worker would get typically if you were unable to return to your job. Although you could still get it if the employer failed to meet certain statutory requirements about giving you a return to work offer. These are going to change in 2016, and they're going to change for the pre-existing voucher program. And the primary change is that the vouchers will now expire, and they're going to expire from 5 years of date of injury or 2 years from the issuance of the voucher. I think the only real issue I see with that is when if you give somebody a voucher that expires in 2 years, and the vouchers can go, presently they can go up to $10,000. If you give them $10,000 in 2 years to spend it, depending, if you go to a community college, you might not be able to do that. And so that's my only issue with that. For the new vouchers, the new rule is you can no longer buy it out. So in a lot of cases, presently, if we have particularly on our older clients who don't intend to ever go back to school, maybe they intend to retire after the injury, and they still qualify for the voucher, we can negotiate a buyout of that voucher for 50 cents on the dollar or something like that. The new vouchers, you can't buy them out, and everyone who has permanent partial disability will get a voucher unless you get a valid return to work offer. And the voucher now is going to be $6,000 for everyone, whereas presently it ranges from a low of 4 to a maximum of 10. And the same expiration is going to apply on those vouchers.
It has some benefit to that voucher, though. They make it a lot easier if you want to get a computer. They give you up to $1,000 for that. You can get $500 for just basically saying you need it. But I'm sure that's going to lead to some litigation. Like they'll probably want to say, well, is that computer needed because you're trying to find alternative work or train yourself or whatever, but it doesn't say anything about that in the regs or the law yet, so it's always a good opportunity to try to get a computer and some money.
Yeah. So there is a return to work program John talked about briefly earlier. It's just a $120 million fund, and it's supposed to reimburse those workers whose permanent disability payments are disproportionately low in comparison to their earnings loss. So those are the two things we know that we can tell you sitting here today, is that there's going to be $120 million out there, and that if your permanent disability was disproportionately low to your loss of earnings because of your injury, you'll be able to go collect from this fund. It was very, very short section of the labor code added in at the last minute. So nobody actually said how it's going to happen. They just said the administrative director will figure it out, and we're still waiting on those regulations to come in. So until we get those regulations, there's really nothing else we can say about that other than it exists.
And since we don't have an administrative director right now, we know we can make those regulations.
Good point.
For those peace officers who might be listening in on our webinar, there's no change to any of the presumptions for peace officers in your 3200 area of the labor code. Even though today we're talking about Senate Bill 863, because we do service a large section of the peace officer community, I wanted to talk briefly about Assembly Bill 2451. This passed the legislature, but as of yesterday afternoon, it's still pending Governor Brown's signature, and I could not tell from the news articles I've read, there's no telling which way Governor Brown's going to go on this. But basically, it would change the death benefit for certain injuries, and it would allow you to file a death benefit under your cancer, tuberculosis, and blood-borne disease presumptions. Those would be able to be filed within 1 year of date of death, and that is regardless of whenever your date of injury was. So if you have cancer today, it goes into remission, and then 5 years and 1 day after you were first diagnosed, it comes back, then your family will still be able to collect death benefits. And it's up in the air. If it passes, then by all means, we might probably send out something in our newsletter regarding it passing or not and how it's going to affect you. But given that we still don't know how it's going to be, I'm not going to spend too much time on that today. So, any questions? If you have any questions, feel free to throw them in the chat box right now, but that is the end of the presentation today. I do have a question. Will this material be available by email or download? Tommy is our IT person. Within the next couple days, he is going to put this video together, and he is going to, the slideshow presentation will be available via email too, and the video will be available for download, I would say within a week. Is that pushing it? Within 1 week, the video should be available for download off of our website. All right, are there any other questions out there? And you're welcome. Thank you for the thank you. Let's see. This could be okay. And I'll shoot. I'm going to send my email out to everybody. Let's see if you have any. I'm sending my email out to everybody. If you do have some specific questions or you want some specific consultation, you can shoot me an email or give the main lines of the office a call, and you can schedule a consultation with one of our workers' compensation attorneys. As far as questions of retirement goes, we do have an attorney in our office. Steve Welty handles all of our disability retirement issues. In general, the workers' compensation, disability, and disability retirement are two separate entities. So if you have questions about disability retirement, we can certainly connect you with the person with those questions who can give you those answers. Will we automatically send the slideshow, or do they need to request it specifically? Well, we haven't decided that one. That's a good question.
Contact us in any way to request it, and we'll put it on.
Yeah,
email it to you.
If you just want to shoot an email to the office, you can reply to the email that was sent out asking you to sign up for this. I believe, can they do that? Yes, they can do that. Send a reply email and we'll get you a copy of the slideshow to you. Any other questions? Is there any changes? Any questions regarding the loss of earnings versus salary is going to be that's going to be covered later on. We've got to wait for the administrative director to come out with regulations for that. And before we end today, I'd like to go ahead and give a shout out. We want to thank Ron Cunningham from PORAC for putting this on and asking us to be here today for you. We thank you, Ron. And with that, that will be an end to our presentation. Thank you very much, and have a good day.
Thank you.
Thank you.